Good morning, everyone. Today is a wonderful day given by God, and it's a wonderful day to study the Taxation Law Review. Okay, let's begin. University of Santo Tomas Taxation Law Review Pre-Week Notes of 2016, Part 7. Our topic for today is a continuation of the Part 6, which is the remedies under the NIRC. The remedies under the NIRC. The last time we are talking about the civil action, and now we will be talking about the criminal action. I repeat, this is about the remedies under the NIRC, and we are in the subtitle of criminal action. Criminal action. The satisfaction of the civil liability is not one of the grounds for the extinction of criminal action. I repeat, in criminal action, the satisfaction of the civil liability is not one of the grounds for the extinction of criminal action. It is found in People versus Ildefonso Tierra, 12 Scra 66, the case of 1964. Likewise, the payment of the tax due after apprehension shall not constitute a valid defense in any prosecution for violation of any provision of the tax code. I repeat, the criminal action. In criminal action, the satisfaction of the civil liability is not one of the grounds for the extinction of criminal action. Likewise, the payment of the tax due after apprehension shall not constitute a valid defense in any prosecution for violation of any provision of the tax code. And that can be found in NIRC Section 253. Next subtopic is the compromise. Compromise. It is one of the remedies under the NIRC. Compromise. Compromise penalty are paid in lieu of criminal prosecution. It may only be enforced by the Commissioner of Internal Revenue with the agreement and conformity of the taxpayer. If rejected, it cannot be enforced through an action in court or by distraint or levy. And that can be found in Wonder Mechanical Engineering Corporation versus Court of Appeals et al., 64 Scra 55. Next is, the Commissioner has the power to accept an offer of compromise in the following cases. I repeat, the Commissioner has the power to accept an offer of compromise in the following cases. There are two cases here. Number one, a reasonable doubt, and number two, a clear inability to pay the assessed tax. I repeat, the Commissioner has the power to accept an offer of compromise in the following cases. Number one, a reasonable doubt, and number two, a clear inability to pay the assessed tax. Okay, number one, a reasonable doubt as to the validity of the claim against the taxpayer exists. Doubtful validity. I repeat, the number one, a reasonable doubt as to the validity of the claim against the taxpayer exists, and that is called doubtful validity. And number two, the financial position of the taxpayer demonstrates a clear inability to pay the assessed tax. I repeat, in number two, the financial position of the taxpayer demonstrates a clear inability to pay the assessed tax, and that is called financial incapacity. So there are two. The Commissioner has the power to accept an offer of compromise in the following cases. Number one, doubtful validity, and number two, financial incapacity. And what is a doubtful validity? Doubtful Validity is a reasonable doubt as to the validity of the claim against the taxpayer exists. And the financial incapacity is the financial position of the taxpayer demonstrates a clear inability to pay the assessed tax. Okay, the compromise settlement is subject to the following minimum amounts. The compromise settlement is subject to the following minimum amounts. Number 1, for cases of financial incapacity, the minimum compromise rate of 10% of the basic assessed tax. I repeat, the compromise settlement is subject to the following minimum amounts. Number 1, for cases of financial incapacity, the minimum compromise rate of 10% of the basic assessed tax. Number 2, for other cases, 40% of the basis tax assessed. Number 2, for other cases, 40% of the basis tax assessed. I repeat, the compromise settlement is subject to the following minimum amounts. Number 1, for cases of financial incapacity, the minimum compromise rate of 10% of the basic assessed tax. And number 2, for other cases, 40% of the basis tax assessed. Next, abatement or cancellation of tax liability. Abatement or cancellation of tax liability. The Commissioner of Internal Revenue may also abate or cancel a tax liability when, number 1, the tax or any portion thereof appears to have been unjustly or excessively assessed. Number 2, the administrative and collection costs involved do not justify collection of the amount due. I repeat, abatement or cancellation of tax liability. The Commissioner of Internal Revenue may also abate or cancel a tax liability when, number 1, the tax or any portion thereof appears to have been unjustly or excessively assessed. That is the number 1 reason, unjustly or excessively assessed. Number 2, the administrative and collection costs involved do not justify collection of the amount due. I repeat, the administrative and collection costs involved do not justly collection of the amount due. And that is found in Section 204 of NIRC. Okay, here's a question here. Question: can the Commissioner of Internal Revenue inquire into the bank deposits of a taxpayer? I repeat, can the Commissioner of Internal Revenue inquire into the bank deposits of a taxpayer? If so, does this power of the Commissioner conflict with the RA 1405 or Secrecy of Bank Deposit Law? The answer is the Commissioner of Internal Revenue is authorized. I repeat, the Commissioner of Internal Revenue is authorized to inquire into the bank deposits of, number 1, a decedent to determine his gross estate. Number 1, to the decedent, a decedent to determine his gross estate. Number 2, any taxpayer. Number 2, any taxpayer who has filed an application for compromise of his tax liability by means of financial incapacity to pay his tax liability. So those are the authorization of the Commissioner of Internal Revenue. I repeat the question and the answer so that it can be fully absorbed. Can the Commissioner of Internal Revenue inquire into the bank deposits of a taxpayer? If so, does this power of the Commissioner conflict with RA 1405 or the Secrecy of Bank Deposit Law? The answer is the Commissioner of Internal Revenue is authorized to inquire into the bank deposits of, number 1, a decedent to determine his gross estate. Number 1, a decedent to determine his gross estate. Number 2, any taxpayer. Number 2, any taxpayer who has filed an application for compromise of his tax liability by means of financial incapacity to pay his tax liability. The limited power of the Commissioner does not conflict with the RA number 1405 because the provisions of the tax code granting this power is an exemption to the secrecy of bank deposit law as embodied in a latter legislation. Furthermore, in case a taxpayer applies for an application to compromise the payment of his tax liabilities on his claim that his financial position demonstrates a clear inability to pay the tax assessed, his application shall not be considered unless and until he waives in writing his privilege under RA number 1405, and such waiver shall constitute the authority of the Commissioner to inquire into the bank deposits of the taxpayer. So I repeat, the limited power of the Commissioner does not conflict with the RA 1405. I repeat, does not conflict with the RA 1405 because the provisions of the tax code granting this power is an exemption to the secrecy of bank deposits law as embodied in a latter legislation. Furthermore, in case a taxpayer applies for an application to compromise the payment of his tax liabilities on his claim that his financial position demonstrates a clear inability to pay the tax assessed, his application shall not be considered unless and until he waives in writing his privilege under the RA 1405, and such waiver shall constitute the authority of the Commissioner to inquire into the bank deposits of the taxpayer. Okay. Cases which cannot be compromised. This must be memorized. Cases which cannot be compromised. There are 7 items that is enumerated here. Cases which cannot be compromised. It must be memorized. Number 1, withholding tax cases. Number 1, withholding tax cases. Number 2, criminal tax fraud cases. Number 2, criminal tax fraud cases. Number 3, criminal violation already filed. Number 3, criminal violation already filed. Number 4, duly approved schedule of installment payments. Number 4, duly approved schedule of installment payments. Number 5, cases where the final reports of reinvestigation or reconsideration have been issued. Number 5, cases where the final reports of reinvestigation or reconsideration have been issued. Number 6, cases which becomes final and executory. Number 6, cases which becomes final and executory. Number 7, estate tax cases where compromise is requested on the ground of financial incapacity of the taxpayer. Number 7, estate tax cases where compromise is requested on the ground of financial incapacity of the taxpayer. Okay, I will read that again. Cases which cannot be compromised. Number 1, withholding tax cases. Number 1, withholding tax cases unless the applicant taxpayer invokes provision of law that casts doubt on the taxpayer's obligation to withhold. Number 1, withholding tax cases unless the applicant taxpayer invokes provision of law that casts doubt on the taxpayer's obligation to withhold. Number 2, criminal tax fraud cases. Criminal tax fraud cases. Criminal tax fraud cases confirmed as such by the CIR. Number 3, criminal violation already filed in court. Number 3, criminal violation already filed in court. Number 4, delinquent accounts with duly approved schedule of installment payments. Number 4, delinquent accounts with duly approved schedule of installment payments. Number 5, cases where the final reports of reinvestigation or reconsideration have been issued, resulting to reduction in the original assessment and the taxpayer is agreeable to such decision. Number 6, cases which become final and executory after the final judgment of the court where compromise is requested on the ground of doubtful validity of the assessment. Number 6, cases which becomes final and executory after the final judgment of a court where compromise is requested on the ground of doubtful validity of assessment. And number 7, the estate tax cases where compromise is requested on the ground of financial incapacity of the taxpayer. Okay. So number 1 of that cannot be compromised is the withholding tax cases. So, and number 2, criminal tax fraud cases. Number 3, criminal violation already filed. And number 4, duly approved schedule of installment payments. Number 5, cases where the final reports of reinvestigation or reconsideration have been issued. Number 6, cases which becomes final and executory. And last is number 7, estate tax cases where compromise is requested on the ground of financial incapacity of the taxpayers. Those are the cases which cannot be compromised. Next topic is the civil penalties. Civil penalties. Civil penalties. Penalty equivalent to 25% of the amount due in the following cases. I repeat, in civil penalties, penalty equivalent to 25% of the amount due in the following cases. Letter A, failure to file any return and pay the tax due thereon as required on the date prescribed. Letter A, failure to file any return and pay the tax due thereon as required on the date prescribed. So, merong penalty equivalent to 25% of the amount due. Number 1, failure to file any return and pay the tax due thereon as required on the date prescribed. So, dapat hindi mag-late sa pag-pay. Okay. Letter B, unless otherwise authorized by the CIR, filing a return with an Internal Revenue Officer other than those with whom the return is required to be filed. Unless, letter B, unless otherwise authorized by the CIR, filing a return with an Internal Revenue Officer other than those with whom the return is required to be filed. And letter C, failure to pay the deficiency tax within the time prescribed for its payment in the notice of assessment. Letter C, failure to pay the deficiency tax within the time prescribed for its payment in the notice of assessment. And letter D, failure to pay the full or part of the amount of tax shown on any return required to be filed or the full amount of tax due for which no return is required to be filed on or before the date prescribed for payment. I repeat, the 25% of the amount due, the 25% penalties of the amount due in the following cases. Number 1, failure to file any return and pay the tax due thereon as required on the date prescribed. Letter B. Letter B is unless otherwise authorized by the CIR. Filing a return with an Internal Revenue Officer other than those with whom the return is required to be filed. And letter C, Failure to pay the deficiency tax within the time prescribed for its payment in the notice of assessment. And letter D, failure to pay the full or part of the amount of tax shown in any return required to be filed, or the full amount of tax due for which no return is required to be filed on or before the date prescribed for payment. Next is, in the cases of willful neglect to file the return, I repeat, in cases of willful neglect to file the return within the period, or in cases of a false or fraudulent return is willfully made, the penalty to be imposed shall be 50% of the tax or of the deficiency tax. In cases of willful neglect to file the return within the period, or in case of false or fraudulent return is willfully made, the penalty to be imposed shall be 50% of the tax or of the deficiency tax. Prima facie evidence of a false or fraudulent return to justify the imposition of a 50% surcharge on the deficiency tax due from a taxpayer. So, kung hindi ka magbayad, yun, 50% na. I repeat, in cases of willful neglect to file the return within the period, or in case of a false or fraudulent return is willfully made, the penalty to be imposed shall be 50% of the tax or of the deficiency tax. Prima facie evidence of a false or fraudulent return to justify the imposition of a 50% surcharge on the deficiency tax due from a taxpayer. It is when the taxpayer substantially underdeclared his taxable sales, receipts, or income, or substantially overstated his deductions. The taxpayer's failure to report sales, receipts, or income in an amount exceeding 30% of that declared per return, and a claim of deduction in an amounting exceeding 30% of actual deduction shall render the taxpayer liable for under-declaration and under-declaration respectively, and will justify the imposition of the 50% surcharge on the deficiency tax due from a taxpayer. So, the prima facie evidence of a false or fraudulent return to justify the imposition of a 50% surcharge on the deficiency tax due from a taxpayer. It is when the taxpayer substantially underdeclared his taxable sales, receipts, or income, or substantially overstated his deductions. The taxpayer's failure to report sales, receipts, or income in an amount exceeding 30% of that declared per return, and a claim of deduction in an amount exceeding 30% of actual deduction shall render the taxpayer liable for under-declaration and over-declaration respectively, and will justify the imposition of the 50% surcharge on the deficiency tax due from the taxpayer. That can be found in NIRC 248. I repeat, NIRC section 248. Next topic is the refund. Next topic is the refund. Refund. There are 3. There are 3 kinds of refund. Number 1, the Supreme Court in Commissioner of Internal Revenue versus Mindanao 2 Geothermal Partnership, January 15, 2014, summarized the rules on the determination of the prescriptive period for filing a tax refund or credit of unutilized input VAT as provided in Section 112 of the 1997 Tax Code as follows. I repeat, number 1, The Supreme Court in Commissioner of Internal Revenue versus Mindanao 2 Geothermal Partnership, January 15, 2014, summarized the rules on the determination of the prescriptive period for filing a tax refund or credit of unutilized input VAT as provided in Section 112 of the 1997 Tax Code as follows. Letter A, 2-year prescriptive period. Letter A, 2-year prescriptive period. Letter B, 120 plus 30-day period. Letter B, 120 plus 30-day period. Okay, let's go back to letter A. Letter A, 2-year prescriptive period. It is only the administrative claim that must be filed within the 2-year prescriptive period. I repeat, it is only the administrative claim that must be filed within the 2-year prescriptive period. And that is found in the Aichi doctrine. Next is the proper reckoning date for the 2-year prescriptive period is the close of the taxable quarter when the relevant sales were made. I repeat, number 2, the proper reckoning date for the 2-year prescriptive period is the close of the taxable quarter when the relevant sales were made. That can be found in San Roque doctrine. Next, the only other rule is the Atlas ruling, which applied only from 8 of June 2007 to 12 of September 2008. Atlas states that the 2-year prescriptive period for filing a claim for tax refund or credit or unutilized input VAT payments should be counted from the date of filing of the VAT return and payment of the tax. That also can be found in San Roque doctrine. I repeat the number 3. The only other rule is the Atlas ruling, which applied only from 8 of June 2007 to 12 of September 2008. Atlas states that the 2-year prescriptive period for filing a claim for tax refund or credit of unutilized input VAT payments should be counted from the date of filing of the VAT return and payment of the tax. I repeat, the category of letter A, the 2-year prescriptive period. Number 1, it is only the administrative claim that must be filed within the 2-year period, prescriptive period. Number 2, the proper reckoning date for the 2-year prescriptive period is the close of the taxable quarter when the relevant sales were made. And number 3, last, is the only other rule is the Atlas ruling, which applied only from 8 of June 2007 to 12 of September 2008. Atlas states that the 2-year prescriptive period for filing a claim for tax refund or credit of unutilized input VAT payments should be counted from the date of filing of the VAT return and payment of the tax. Okay, let's go to the next subtopic, the 120 plus 30-day period. 120 plus 30-day period. Number 1, the taxpayer can file an appeal in one of 2 ways. The taxpayer can file an appeal in one of 2 ways. Number 1, file the judicial claim within 30 days after the commissioner denies the claim within the 120-day period. Or, the number 2, file the judicial claim within 30 days from the expiration of the 120-day period if the commissioner does not act within the 120-day period. I repeat the number 1 of the 120 plus 30-day period. Number 1, the taxpayer can file an appeal in one of two ways. Number 1, file the judicial claim within 30 days after the commissioner denies the claim within the 120-day period. And number 2, file the judicial claim within 30 days from the expiration of the 120-day period if the commissioner does not act within the 120-day period. Next, number 2, the 30-day period always applies. Number 2, the 30-day period always applies, whether there is a denial or inaction on the part of the CIR. Number 2, the 30-day period always applies, whether there is a denial or inaction on the part of the CIR. Number 3, as a general rule, the 30-day period to appeal in both mandatory and jurisdictional. I repeat, as a general rule, the 30-day period to appeal in both mandatory and jurisdictional, it is found in Aichi and San Roque Doctrine. Number 4, as an exemption to the general rule, premature filing is allowed only. Premature filing is allowed only if filed between the 10th of December 2003 and 5th of October 2010 when the BIR rolling number DA-489-03 was still in force, and that can be found in San Roque Doctrine. And last is number 5, late filing is absolutely prohibited. Late filing is absolutely prohibited even during the time when BIR ruling number DA-489-03 was in force. Okay, number 2 of the category of the refund, because the number 1 is the Supreme Court versus Commissioner of Internal Revenue, and the number 2 is a deficiency tax assessment. Number 2 is a deficiency tax assessment a bar to claim for tax refund or tax credit that was asked in 2005 bar exam. I repeat the question. Is a deficiency tax assessment a bar to a claim for tax refund or tax credit? The answer is yes. The deficiency tax assessment is a bar to a tax refund or credit. The taxpayer cannot be entitled to a refund and at the same time liable for a tax deficiency assessment for the same year. The deficiency assessment creates a doubt as to the truth and accuracy of the tax return. Said return cannot therefore be the basis of the refund. And that can be found in CIR versus CA, JR number 106611, July 21, 1994. Next is number 3. Number 3 of the kinds of refund. Number 3, distinction between an excess input tax and an excessively collected tax. I repeat, distinction between an excess input tax and an excessively collected tax. Letter A. In a claim for refund or credit of excess input VAT under Section 110B and Section 112A, the input VAT is not excessively collected as understood under Section 229. At the time of the payment of the input VAT, the amount paid is the correct and proper amount. The person legally liable for the input VAT cannot claim that he overpaid the input VAT by the mere existence of an excess input VAT. The term excess input VAT simply means that the input VAT available as credit exceeds the output VAT. Repeat the letter A. In a claim for refund or credit of excess input VAT under Section 110B and Section 112A, the input VAT is not excessively collected as understood under Section 229. At the time of payment of the input VAT, the amount paid is the correct and proper amount. The person legally liable for the input VAT cannot claim that he overpaid the input VAT by the mere existence of an excess input VAT. The term excess input VAT simply means that the input VAT available as credit exceeds the output VAT. Okay, next, letter B. From the plain text of Section 229, it is clear that what can be refunded or credited is a tax that is erroneously, illegally, excessively, or in any manner wrongfully collected. I repeat, from the plain text of Section 229, it is clear that what can be refunded or credited is a tax that is erroneously, illegally, excessively, or in any manner wrongfully collected. In short, there must be a wrongful payment because what is paid or part of it is illegally due. Okay, from the plain text of Section 229, it is clear that what can be refunded or credited is a tax that is erroneously, illegally, excessively, or in any manner wrongfully collected. In short, there must be wrongful payment because what is paid or part of it is illegally due. I will read again the whole text of refund. Number 1, the Supreme Court in Commissioner of Internal Revenue versus Mindanao 2 Geothermal Partnership, January 15, 2014, summarized the rules on the determination of the prescriptive period for filing a tax refund or credit of unutilized input VAT as provided in Section 112 of the 1997 Tax Code as follows. Letter A, 2-year prescriptive period. Letter B, 120 plus 30-day period. Letter A, 2-year prescriptive period. It is only the administrative claim that must be filed within the 2-year prescriptive period, and that is found in Alchi Doctrine. Number 2, the proper reckoning date for the 2-year prescriptive period is the close of the taxable quarter when the relevant sales were made. That is also found in San Roque Doctrine. Number 3, the only other rule is the Atlas ruling, which applied only from 8th of June 2007 to 12th of September 2008. Atlas states that the 2-year prescriptive period for filing a claim for tax refund or credit of unutilized input VAT payments should be counted from the date of filing of the VAT return and payment of the tax. That is only found in San Roque. And letter B, the 120 plus 30-day period is number 1. The taxpayer can file an appeal in one of 2 ways. Number 1, file the judicial claim within 30 days after the commissioner denies the claim within the 120-day period. Or number 2, the judicial claim within 30 days from the expiration of the 120-day period if the commissioner does not act within the 120-day period. Next, number 2, the 30-day period always applies whether there is a denial or inaction on the part of the CIR. Number 3, as a general rule, the 30-day period to appeal is both mandatory and jurisdictional. That is also found in Aichi and San Roque Doctrine. Number 4, as an exemption to the general rule, Premature filing is allowed only if filed between 10th of December 2003 and 5th of October 2010, when the BIR ruling number DA-489-03 was still in force. That is also found in San Roque ruling. And last, number 5, late filing is absolutely prohibited even during the time when the BIR ruling number DA 489-03 was in force. Number 2, is a deficiency tax assessment a bar to a claim for tax refund or tax credit? The answer is yes. The deficiency tax assessment is a bar to a tax refund or credit. The taxpayer cannot be entitled to a refund and at the same time liable for a tax deficiency assessment for the same year. The deficiency assessment creates a doubt as to the truth and accuracy of the tax return. Said return cannot therefore be the basis of the refund. And last, the number 3, distinction between an excess input VAT and an excessively collected tax. In a claim for refund or credit of excess input VAT under Section 110B and Section 112A, the input VAT is not excessively collected as understood under Section 229. At the time of payment of the input VAT, the amount paid is the correct and proper amount. The person legally liable for the input VAT cannot claim that he overpaid the input VAT by the mere existence of an excess input VAT. The term excess input VAT simply means that the input VAT available as credit exceeds the output VAT. And letter B, from the plain text of Section 229, it is clear that what can be refunded or credited is a tax that is erroneously, illegally, excessively, or in any manner wrongfully collected. In short, there must be a wrongful payment because what is paid or part of it is legally due. Next topic is the Court of Tax Appeals. The Court of Tax Appeals, RA 9282. Court of Tax Appeals, RA 9282. Court of Tax Appeals can take cognizance of petition for certiorari. Court of Tax Appeals can take cognizance of petitions for certiorari. City of Manila versus Honorable Caridad H. Garcia, Cuerdo, February 4, 2014. The court held that while there is no express grant of such power, with respect to the CTA, Section 1, Article 8 of the 1987 Constitution provides that judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. On the strength of the above constitutional provisions, it can be fairly interpreted that the power of the Court of Tax Appeals includes that of determining whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the RTC in issuing an interlocutory order in cases falling within the exclusive appellate jurisdiction of the tax court. It thus follows that the CTA has constitutional mandate and is vested with jurisdiction to issue writs of certiorari in these cases. I repeat, the Court of Tax Appeals RA 9282. Court of Tax Appeals can take cognizance of petition for certiorari. The example case is City of Manila versus Honorable Caridad H. Grisia Cuerdo, February 4, 2014. The court held that while there is no express grant of such power with respect to the CTA, Section 1, Article 8 of the 1987 Constitution provides that judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. On the strength of the above constitutional provisions, it can be fairly interpreted that the power of the Court of Tax Appeals includes that of determining whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the RTC in issuing an interlocutory order in cases falling within the exclusive appellate jurisdiction of the tax court. It thus follows that the CTA, by constitutional mandate, is vested with jurisdiction to issue writs of certiorari in these cases. Okay, next topic is the local government taxation. The local government taxation. In this topic, we are going to read the constitutional basis, the nature and source of taxing power, the residual taxing power of local governments, and the scope of taxing power. Okay, let's go back to the constitutional basis. I repeat, our topic is local government taxation, constitutional basis. Okay, each local government unit shall have the power to create its own sources of revenue and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide, consistent with the basic policy of local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local governments, and this is found in Section 5, Article 10 of 1987 Constitution, Section 129 of the Local Government Code. I repeat, the constitutional basis of the local government taxation, that each local government unit shall have the power to create its own sources of revenue and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide, consistent with the basic policy of the local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local government. Next, Congress cannot pass a law abolishing this power of the LGU. I repeat, the Congress cannot pass a law abolishing this power of the LGUs. Okay, the Congress cannot pass a law transferring this power to the LGUs to raise revenues to agencies, for it amounts to deprivation of the local government units of this power. I repeat, the Congress cannot pass a law transferring this power of the local government units to raise revenues to agencies, for it amounts to deprivation of the local government units of this power. Next, all local government units have the general authority to raise revenues. I repeat, all local government units have the general authority to raise revenues. Before, the barangays don't. But because of the Republic Act 7160, gave the barangays the general power or authority to raise the revenue. However, the local governments have no power to tax instrumentalities of the national government, like the PAGCOR. I repeat, however, the local governments have no power to tax instrumentalities of the national government like the PAGCOR. This doctrine emanates from the supremacy of the national government over the local governments. The power to tax cannot be allowed to defeat an instrumentality or creation of the very entity which has the inherent power to wield it. Local government in such a system can only mean a measure of decentralization of the function of the government. And that doctrine is found in Basco versus PAGCOR. Now, the doctrine of supremacy of national government over the local government is found also in Mactan Cebu International versus Marcos, and see also the section 133 of the Local Government Code on common limitations. Next, the fundamental principles governing the taxing powers of the local government units as laid out in Section 130 of the Local Government Codes. I repeat, the fundamental principles governing the taxing powers of the local government units as laid out in Section 130 of the Local Government Codes are: number 1, taxation shall be uniform in each local government units. I repeat, taxation shall be uniform in each local government units. Number 2, taxes, fees, charges, and other imposition shall be equitable and based as far as practicable on the taxpayer's ability to pay. I repeat, number 2, taxes, fees, charges, and other impositions shall be, letter A, be equitable and based as far as practicable on the taxpayer's ability to pay. Letter B, it must be levied and collected only for public purposes. I repeat, it must be levied and collected only for public purposes. Letter C, it must not be unjust, excessive, oppressive, or confiscatory. I repeat, it must not be unjust, excessive, oppressive, or confiscatory. Letter D, it must not be contrary to law, public policy, national economic policy, or in the constraint of trade. I repeat, it must not be contrary to law, public policy, national economic policy, or in the constraint of trade. Okay, number 3, the collection of local taxes, fees, charges, and other impositions shall in no case be let to any private persons. So, dapat to the government persons or to the government only that has the power, not the private person. I repeat, the collection of local taxes, fees, charges, and other impositions shall in no case be let to any private persons. Number 4, the revenue collected pursuant to the provisions of the Local Government Code shall inure solely to the benefit of and be subject to the disposition by the local government units levying the tax, fees, charge, or other imposition unless otherwise specifically provided by the Local Government Code. I repeat, number 4, the revenue collected pursuant to the provisions of the Local Government Code shall inure solely to the benefit of and be subject to the disposition by the local government unit levying the tax, fee, charge, or other imposition unless otherwise specifically provided by the Local Government Code. Note, exceptions are Section 138 and 164 of the Local Government Code. These sections provide for allocation in Section 138, which is the 30% to the province, the 30% to the component city or municipality, 40% to the barangay, and in Section 164, 50% to the general fund of the city or municipality and 50% to the barangay. Next, number 5, each local government unit shall, as far as practicable evolve as progressive system of taxation. I repeat, each local government unit shall, as far as practicable, evolve a progressive system of taxation. This doctrine is found in Pilisloy Realty Corporation versus the Province of Benguet, JR number 183137, April 10, 2013, and 695 SCRA 491, cited in Film Development Council of the Philippines versus Colon Heritage Realty Corporation, ETC, JR number 203754, and companion case June 16, 2015. I repeat, the fundamental principles governing the taxing powers of the local government units as laid out in Section 130 of the Local Government Codes are: number 1, taxation shall be uniform in each local government units. Number 2, taxes, fees, charges, and other limitations shall be equitable and based as far as practicable on the taxpayer's ability to pay. Letter B, taxes, fees, charges, and other impositions shall be levied and taxes only for public purposes, and shall not be unjust, excessive, oppressive, or confiscatory, and must not be contrary to law, public policy, national economic policy, or in the restraint of trade. And number 3, the collection of local taxes, fees, charges, and other impositions shall in no case be led to any private persons. And number 4, the revenue collected pursuant to the provisions of the LGU shall inure solely to the benefit of and be subject to the disposition by the local government units, levying the tax, fees, charges, or other impositions unless otherwise specifically provided by the local government code. And last, number 5, each local government unit shall, as far as practicable, evolve a progressive system of taxation. Okay, next subtopic is the nature and sources of taxing power. The nature and sources of taxing power. Okay, the power of taxation of the local government units is merely a delegated power. The local government units are able to legislate only by virtue of a valid delegation of legislative power from the national legislature, and they are mere agents vested with what is called the power of subordinate legislation. I repeat, the nature and sources of taxing power is that the power of taxation of the local government is merely a delegated power. The local government units are able to legislate only by virtue of a valid delegation of legislative power from the national legislature, and they are mere agents vested with what is called the power of subordinate legislation. Okay, these are the nature and sources of the taxing power. Number 1, the municipal corporation have no inherent power to tax. I repeat. Number 1, the municipal corporation have no inherent power to tax. Number 2, the charter must show an intent to confer the power or the municipality cannot assume it. Number 2, the charter must show an intent to confer that power or the municipality cannot assume it. Number 3, strictissimi juris, or any doubt or ambiguity arising out of the term used in granting the power, must be resolved against the municipality, which is subject to such guidelines and limitations set by the Congress. In this case, an ordinance imposed tax based upon the output of production and not upon the gross sales or receipts as authorized by the local government code. I repeat, it is the strictissimi juris. Any doubt or ambiguity arising out of the term used in granting the power must be resolved against the municipality, which is subject to such guidelines and limitations set by the Congress. In this case, an ordinance imposed tax based upon the output of production not upon the gross sales or receipts as authorized by the local government code. Next, number 4. The power of local government units to tax is not a mere delegation by Congress, but it is based upon the Constitution. The Constitution limits the rule of Congress on the matter to prescribing the guidelines and limitations, but always consistent with the basic policy of local autonomy. I repeat, the power of the local government units to tax is not a mere delegation by Congress. It is based upon the Constitution. The Constitution limits the rules of Congress on the matter to prescribing the guidelines and limitations, but always consistent with the basic policy of the local autonomy. Number 5, Congress cannot deprive but only limit the power of the local government units to tax. I repeat, the Congress cannot deprive but only limit the power of local government units to tax. Number 6, Congress may still enact local tax laws. I repeat, the Congress may still enact local tax laws. When the power to tax was given to local governments, Congress was not divested of its power to enact local tax laws. I repeat, the Congress may still enact local tax laws. When the power to tax was given to the local governments, the Congress was not divested of its power to enact local tax laws. And last, the number 7 is that it is not absolute as it is subject to limitations provided by law. I repeat, it is not absolute as it is subject to limitations provided by law. And those are the nature and sources of the taxing power. I repeat, municipal corporations have no inherent power to tax. Second, the character must show an intent to confer the power or the municipality cannot assume it. Number 3, strictissimi juris, any doubt or ambiguity arising of the term used in granting the power must be resolved against the municipality, which is subject to such guidelines and limitations set by the Congress. Number 4, the power of the local government units to tax is not a mere delegation by Congress, but it is based upon the Constitution. Number 5, the Congress cannot deprive but only limit the power of local government units to tax. Number 6, Congress may still enact local tax laws when the power to tax was given to local government units. Congress was not divested of its power to enact local tax laws. And last, number 7, it is not absolute as it is subject to the limitations provided by the law. Alright, next subtopic is the residual taxing power of local governments. I repeat, the residual taxing power of local governments. Like the national government, the local government units do have this residual power of taxation, which is the power to impose taxes, fees, and charges which do not fall within the scope of taxes enumerated under the local government code, as well as those which are levied on subjects or bases which are not taxed under the NIRC as amended or other applicable laws. I repeat, the residual taxing power of the local governments. Like the national government, the local government units do not have this residual power of taxation, which is the power to impose taxes, fees, and charges which do not fall within the scope of taxes enumerated under the local government code, as well as those which are levied on subjects or bases which are not taxed under the NIRC as amended or other applicable laws. Thus, the local governments may, under their residual taxing powers, raise revenue through other sources, such as the imposition and collection of market stall fees, slaughterhouse fees, or charges for holding benefits shows, public utility charges rendered in operation of public utilities owned operated and maintained by them, tools for maintenance for any road, canal, bridges, or ferry within its territory, or for repaying borrowings for their construction and service charges. I repeat, thus, the local government may, under their residual taxing powers, raise revenue through other sources such as the imposition and collection of market stall fees, slaughterhouse fees, or charges for holding benefit shows, public utility charges rendered in operation of public utilities owned, operated and maintained by them, tolls for maintenance for any road, canal, bridges, or ferry within its territory, or for repaying borrowings for their construction and service charges. That can be found in LIM Comprehensive Reviewer in Taxation of 2010 edition. Next, the common taxes charges that may be imposed by the local government units is subject to the utility or the public utility charges, the service charges, and the toll fees. I repeat, the common taxes or charges that may be imposed by the local government units are the public utility charges, the service charges, and the toll fees. Next is the scope of taxing power. The scope of taxing power, which is our last topic for this Part 7, the scope of taxing power. The scope of taxing power. The local government taxation covering the imposition of license, taxes, fees, and other impositions, including the Community Development Tax or the CEDULA, which is found in RA 7160 of the Local Government Code of 1991. And next is the real property taxation, which is a system of levy on the real property imposed on a countrywide basis. I repeat, the scope of taxing power of the local governments are: number 1, the local government taxation covering the imposition of license taxes, fees, and other impositions, including the Community Development Tax or the CEDULA. That is found in Republic Act 7160 or the Local Government Code of the Philippines. And next is the real property taxation, which is a system of levy on real property imposed on a countrywide basis. And that would be all for today for our Part 7, and I will be back for our Part 8 of UST Taxation Law Review. Thank you so much for listening. I do hope I contributed something to help your taxation law review for the Philippine Bar exam. If I do, please hit the like and subscribe button. Thank you so much, and God bless everyone.